Murray Wells from the Shelby County Bar, representing the appellants, Betty Ross et al. I'd like to reserve 2 minutes for rebuttal in this matter.
2 minutes.
Yes, Your Honor.
All right, you may proceed.
Your Honor, please. This is a fairly narrow and distinct issue. This case arises out of a personal injury claim that was made in General Sessions Court in 2014, wherein my clients alleged that a Miss Alisie Jackson injured them in the operation of a motor vehicle.
With all due respect, I always smile when somebody says it's a very narrow and distinct issue.
I hope to get there, and I hope to make the smile wider and it be that. But there was a UM at play. UM was served. Miss Jackson was never located and was not served. The matter progressed through General Sessions after a series of resettings in which the UM counsel for State Farm participated. Caleb Merriweather was a lawyer at the time, and we couldn't find her. Judge Donald recommended service by publication. I'm not here to argue whether that's correct or not, but that was the direction of the court and the direction.
Well, to the extent that you don't argue that it's correct or incorrect, it's incorrect, would you say?
I don't dispute that that maybe it should have been done another way, but that was the direction of the court, and not at the impetus of the plaintiff, but rather the direction of the court. And plaintiffs followed that direction down the line, published that matter 3 times in the Memphis Daily News, eventually came back to the same court who had retained that file. At that point, a judgment was issued on behalf of each of the 3 plaintiffs against the defendants. UM sort of abstained and didn't get involved. At no point was Ms. Jackson involved in the case. Later, but more than 10 days later, admittedly, that judgment was presented to Ms. Jackson's insurance carrier. And here's where sort of what I believe the simple issue lies. Ms. Jackson was never located by the insurance company. Ms. Jackson has never participated in any way. And so I believe...
How do we know, with all due respect, they don't know where Ms. Jackson is? Is that part of the record? It is part of the record, okay. And I believe Ms. Stewart will testify that well, not testify, but rather argue today that there's never been any contact with Ms. Jackson. All right, that's one of the missing questions there. The question then becomes, there was a petition for writ of mandamus and superseding to the circuit court of Shelby County. I believe you mean certiorari. Certiorari. You're right, Your Honor. That's where the issue rises. And the question is today the same as the question it was then. How is Ms. Jackson pursuing this matter? Ms. Jackson is not a client under contract. Ms. Jackson has certainly not been.
Is there any question that Ms. Stewart represents Ms. Jackson's insurance carrier?
I don't believe there's a question of that. The question is whether or not. You don't dispute that? I don't dispute that she represents the carrier. No.
And that it's the defendant's carrier.
I agree with that as well, Your Honor. I don't dispute any of that. And that brings us to the narrow issue, really, that we argued at the time and we argue now, is that there is, of course, a contractual relationship between the insurance carrier, the defendant, but under Gibbons v. Milliken. Was the insurance contract ever submitted as proof to the court? No, Your Honor. Did you stipulate that? No, Your Honor. Then how did the court make that decision? I have no idea, Your Honor. That's what we're appealing, is the decision of the court to allow us to proceed. Was it ever raised? Yes. Yes, the original, that's why we're here, was our motion to dismiss, and our argument throughout that case, which lasted for years, was that there is no contractual agreement between the defendant and counsel. And that counsel was there not representing defendant's interest because it could have never consulted with the defendant. Rather, only could have consulted with the insurance company. Well, I think your first question should be, is there a contractual agreement between the insurance company and the defendant? I agree, Your Honor, and I think that another way that should have, maybe could have been done, the insurance company was well aware of the claim. They were well aware of the statute of limitations. The UM participated and actively engaged in the general sessions matter. There was no reason that the insurance company couldn't have been aware that there was a lawsuit down there or that a judgment was taken. Certainly, there is a cause of action that the insurance carrier could have made against Ms. Jackson by way of a deck action. And they could have determined the rights and obligations under that contract through that deck action. But they chose not to do that. They chose not to follow what was happening at the general sessions, and they chose to sit and wait and let a judgment be taken, whether proper or not.
And then they weren't obligated to do that, were they?
Certainly not. But the question then becomes, how do you have the authority without consulting your client to make a decision to appeal something to circuit court that it could expose the client? I argue this initially at the circuit court. If a judgment were to be entered against Ms. Jackson for a larger amount than either the judgment downstairs, who knows what a jury would do? The matter goes to a jury. Ms. Jackson's now got a judgment against her exceeding policy limits. Those are decisions. Now, Givens v. Mulliken says a lot of things about what counsel for the insurance company retained by the insurance policy can do and what choices that lawyer can make. And it's pretty broad. But what the law never says, what the case never says, is that you can do all of it without ever having a contract with the defendant. What that case never says, and what no case, and I believe I argued this in the brief, and I've called around, I've done a national search. I can't find any case that says absent any agreement, absent any participation, absent knowing where this person is, you get to make decisions. And we're still here today when Ms. Jackson is going to be represented today in this appeal. She's never been consulted in any way. And that's why we're here, Your Honor. The only other point that I would argue to the court is that we do not have a final judgment as a State Farm. I know they filed a brief and they concur that this contractual obligation between the insurance company and the defendant somehow gives them the right to just fully defend them all the way down the line, making all decisions, making special appearances in the name of that person, making a decision to appeal that could expose that person to financial risk. They agree with that, but that matter is still pending now in circuit court. The relief we're requesting is that the court reverse the decision of the trial court granting its ability to hear that. And as the court was well aware, the case below is not the same as the case in circuit, because now it's not between the parties, it's about the judge, right? Now we have a different position. You're arguing not about the case, but you're arguing that the court did something wrong. And so what we're asking to do is to...
Is there a UM claim in it? I know you've made a UM claim, but do we have an uninsured motorist here?
We do. They're here today. I think you're going to hear from them. I think they've briefed the matter. Their argument when we get...
No, I mean, as I understand it, the defendant was insured.
That's right. We claimed against both, and the argument when we go back down with respect to UM is going to be that there was an insured defendant. The defendant's insurance company is going to argue, well, you don't have service, but we get to represent this person. And so it's at the end of the day, I'm going to be left with 3 injured parties.
But what you're saying, and I understand what you're saying, that this order, the order that was entered by the trial court doesn't mention State Farm. It only addresses this defendant insurance company, or this defendant, and it makes that order final pursuant to 5402.
Yes, Your Honor.
So State Farm, as the uninsured motorist, is still in court.
Yes, Your Honor. That's my understanding of the order. That was my understanding when I went back and reread the transcripts from before, that they still remain in it.
Right. So we have a final judgment as to this defendant.
That's my understanding, that we are here today. Of course,
there's no final judgment as to State Farm.
Yes, that is correct, Your Honor. That's where we are, and maybe we're back here another day. I don't know, but
And so everybody agrees that there's still a pending case in circuit against State Farm? Am I hearing that correctly?
well, I can't speak for what State Farm believes, but I think that's what the order reflects. I think that's what the transcript reflects, and I believe that was the intention of the parties, that the court did not rule as to whether or not the issue on State Farm. And so the reason that we're here as to the defendant Jackson, why this became a final judgment, was about service, and this thing went on for years and years, and we didn't reissue service. Ms. Jackson somehow decided to contest the reissuance of the service. State Farm was served below. State Farm was just a carry-along. State Farm's service issue was resolved at the General Sessions level and came with up to Circuit Court.
So does this order from the trial court require 54.02 language, since you've got another party out there and another claim?
Potentially.
There's no, and as I understand it, there's no, you don't contest the fact that the statute has run based on the failure to reissue the summons.
I'm not here today to make that argument, Your Honor. We reissued and reissued, and at some point there was a lapse, and this thing would have run into perpetuity because we couldn't find her today. And trust me, in this case, I have made every Herculean effort to locate this defendant. I believe she was in Texas at some point. Tried to find her down there. We continue to reissue, and at some point, yes.
So this is all about standing?
Yes. That's why I said I think this is maybe a little simpler than it looks. This is about whether or not.
And what's the relief you're seeking here?
The relief I'm seeking is to reverse the decision of trial court to accept the petition and to overturn or set aside the judgment, saying that they didn't have standing to raise that argument in front. And that was the argument we made, of course, at the onset of the petition being filed by Ms. Jackson's lawyer without Ms. Jackson's advice, participation, counsel, or input. So that's.
So your position is that if Ms. Jackson's insurance carrier doesn't have standing, that your judgments in the General Sessions Court are valid and final?
That's right. There is no mechanism to otherwise set that aside, and those happen every day that remain unchallenged. But that is the position, Your Honor. There's nothing further.
Thank you for that narrow and concise issue.
Good morning. I'm Melanie Stewart from the Memphis Bar, and I have appeared specially throughout this case with Judge Weiss's permission because Ms. Jackson has never been served. There's two things we know. She has never been personally served.
So are you appearing specially today?
Beg your pardon?
Are you appearing specially today?
Yes, Your Honor. I have always appeared specially in the case.
Okay. I'm not sure about that, but go ahead.
Okay, at any rate, there's no personal service on Ms. Jackson, nor has there ever been, number one. And number two, the time has run to...
Hold on just a second. I assume there's going to be more than one person making argument.
Beg your pardon?
Are you the only person arguing today? Presenting oral argument?
Well, State Farm's attorney is here today.
Yes, I see, Mr. Fox. The question is he going to argue today?
I believe he is. He filed a separate brief, Your Honor.
Well, you've only got 15 minutes between the two of you.
That's fine, Your Honor.
I just need 2 minutes.
Okay. That's my question. is
I'm terribly
how
sorry.
we're dividing time. Okay. 13 and 2, is that accurate? Is that correct?
Yes, Your Honor. Thank you.
Thank you. There you go.
At any rate, the time has run to issue a summons for Ms. Jackson. So that leaves us down, as Mr. Wells has pointed out, the only question is whether I have standing to represent Ms. Jackson. Ms. Jackson was insured by Mountain Laurel Assurance Company, which is a progressive company. It's a bit disingenuous for Mr. Wells to claim there's no standing when he...
Let me ask one question. Was the insurance contract ever presented to the court?
No, Your Honor, but there are 3 affidavits from adjusters that are filed in the record because at one point
And they say what?
Beg your pardon?
They say what?
To affirm that and testify in the original hearing that Mr. Wells never requested the last known address for Ms. Jackson, because that was an issue at one point.
Okay.
The insurance contract was not a part of the record.
Then how can the court determine that you have or you do? How can the court determine that there is a contractual obligation between the insurance company and the defendant here?
Well, the way we're here in the first place is Mr. Wells called the insurance company and asked them to pay the judgment.
Hold on just a second. Bear with me. Answer my question.
I understand.
How can the court, the trial court, in the first instance, determine there is a contractual relationship between the insurance company and the defendant?
The contract is not of record, Your Honor.
Ma'am?
The contract is not, the insurance contract is not of record.
Okay.
There's no proof in this record that there's an insurance contract.
So how can the court then, based upon the pleadings, the writ of certiorari and supersedis that has been filed here, how can the court look at the record and make the determination that, yes, there is an obligation for defense here?
Well, Your Honor, on a writ of certiorari is to correct a lower tribunal, and this is an improper judgment that was taken.
Oh, you're not
There's no
answering my
jurisdiction.
question. How can the court make that determination? What evidence is in the record before the trial court to determine?
There's none, Your Honor.
There is none. Then how can the court do that?
There is none. Thank you very much.
I don't mean to cut you off.
Well, Your Honor, if the court is ruling...
I'm asking a question. And now, if you want to waive the rest of your oral argument, that's fine. I'm not cutting you off, and I'm not making a determination. I'm asking the question. Now, if you've got other argument you'd like to make, please proceed.
Your Honor, in the Continental Insurance Company versus Masters case, it's an unreported decision from 1993. A very similar argument was made that the insurance company did not have standing. And the case is almost exactly like this case. A judgment was taken with no service of process. Continental Insurance took a different approach. They filed a declaratory judgment action in Chancery Court and requested an injunction to say a declaratory judgment that the judgment was not valid from General Sessions Court, and an injunction to prohibit the plaintiff from attempting to collect the judgment. In that case, standing was issued.
That makes a difference, though, doesn't it? If they're filing a declaratory judgment action, then they likely presented the contract to the court.
In the Continental Insurance?
Do we know what occurred in that case?
It's not in the slip opinion on whether the contract was asserted, was produced. But there's, as in this case, there's never been a question as to whether there was an insurance contract and whether the debtor was insured.
I mean, I think I asked Mr. Wells that and he agreed that you represented the insurance company, you represented the defendant's
I was
insurance company.
hired by the insurance company. My client would be Ms. Jackson, they're insured. It's that tripartite agreement that's discussed.
Right. And I believe he stipulated, I don't want to call it a stipulation, but I did ask the question of whether there was any question that you represented Ms. Jackson's insurance company, and he indicated that there was no question about it. As you said, he contacted your company.
Right.
There's
He contacted the insurance company, and they immediately called me to represent Ms. Jackson, especially because this judgment was unlawful. But at any rate, in Continental Insurance Company, the Court of Appeals stated, we are satisfied, let me see, I'm sorry. Standing is a judge-made doctrine that prevents a party from prosecuting an action where the party's interests are not affected thereby. A party has standing if it has a personal stake in the outcome of the controversy. We think Continental had a personal stake in a decision concerning the validity of a judgment against its insured, one where the judgment creditor was demanding payment from the insurer. On July 28, 2016, the only avenue open to Ms. Jackson, or through the insurance carrier, was a writ of certiorari. So, and that's what was filed in this case.
Is that Continental case cited in your brief?
Yes,
Stewart?
yes, Your Honor, it is.
Okay.
Thank you very much.
Thank you. Mr. Box, I believe you got 2 minutes.
May it please the court, I represent State Farm, the uninsured motorist carrier. Back in 2016,
Mr. Box, and I know you only have 2 minutes, but I can't tell from this judgment that the judgment that it applies to State Farm.
well, that's exactly the point I wanted to clarify. Caleb Merriweather, who worked with me at the time, was the lead counsel in this case, and he and Mr. Wells had discussed back in 2016 that Mr. Wells was trying to get service on the named defendant. And Mr. Merriweather, through conversations and emails, understood that the matter would be passed. And Mr. Wells actually took a default judgment, or a judgment, wouldn't be default, a judgment against not only the named defendant, but also State Farm. And a few days later, Mr. Merriweather raised that with Mr. Wells, and Mr. Wells, I think he will acknowledge today, agreed that that was an oversight, a mistake, and that he would agree to set aside the judgment as to State Farm. And I just wanted to make sure that was stated on the record, that that's the way we got here, that there was a judgment that I believe Mr. Wells did not intend to take, realizing that he had discussed with my office the fact that the matter would be passed.
Has that judgment been set aside?
I don't believe so.
Well, this judgment is not final against State Farm, the best I can tell.
Okay. Well, that was actually reassuring and comforting to me to hear you say that. The only other matter, and you've already raised it, Tennessee.
So if that's the agreement you have, I mean, apparently you can, of course, Judge Weiss is not there anymore, but that, assuming that is the case, then that judgment can be still be set aside, because I don't believe it's final. Based on this judgment.
That's certainly reassuring to my client.
It made it final as to the other defendant, but it doesn't mention State Farm.
And the only other point I wanted to make, which you made previously, there's a tremendous amount of Tennessee case law that says that simply you can't even invoke the uninsured motor statute when you're dealing with an insured party, and everyone here acknowledges that this defendant, whether served or unserved, was certainly insured. That's all we have.
Let me make sure I understand what you just argued. So a judgment was taken against State Farm in General Sessions?
That's correct. And I think it was 10 days later, I could tell you for sure, that Mr. Wells acknowledged that that was an oversight and he would agree to set that aside.
But within that 10 days, you were not aware of it and you didn't file an appeal of the General Sessions judgment?
That's right.
Okay.
Thank you, sir.
Thank you.
Mr. Wells, you have 2 minutes, I believe.
See if I can just make it simple, Your Honor. Obviously, the Continental case is exactly kind of at the heart of what this court should be looking at, is that was a declaration of rights between parties, between an insurance carrier and the insured. That was a contractual analysis that we don't have in this case, and which is why I argued earlier that declaratory action between those two parties, declaring the rights and obligations of Ms. Jackson and the insurance company, would have been an appropriate vehicle at any point for those two to determine what obligations and rights the insurance company has to stand in the shoes of a named defendant, and then make substantive decisions all the way up to the Tennessee Court of Appeals on behalf of that named defendant that they've never talked to. So those rights should have been set aside in a contractual analysis. Maybe that could have been a hybrid that could have been done in circuit court had they made that argument, had they presented a contract.
Was that issue raised with the circuit court judge?
We raised the issue that they didn't have standing and that there was no contract, no contractual privity between Ms. Stewart and Ms. Jackson.
What did the trial court do with that?
The court rejected that argument.
You just said that there was no contractual privity, but previously you said that there was no question that Ms. Stewart represented Ms. Jackson's insurance company.
That's correct. I'm talking, there's a three-part relationship, and the part that I'm talking about is the part between Ms. Jackson and Ms. Stewart. Ms. Stewart is here today not on behalf of an insurance company. She's never appeared on behalf of an insurance company. She was retained by an insurance company, but her representation has remained only for the named defendant, Ms. Jackson, and there's never been a determination of the rights or standing or how it is that she could make such decisions. With respect and deference to State Farm, I don't disagree with the statements made by Mr. Box. Mr. Mayweather and I did carry that matter on, and I'm happy to talk to them. However, that posture did change a little bit when they joined in with everything that Ms. Jackson or the insurance company, whoever it was, began to argue in circuit court. Thank you for your time.
Thank you. Thank you. We will take this matter under advisement and endeavor to render an opinion at the earliest possible time. Sanjay, we're going to take a very brief recess. We will return shortly so you can have the next parties